government interest. So, that is not the issue for anyone who can do it. So, so personal interest, it's not because of other community interest, I mean communal interest, I mean educational interest. Personal interest must not be, so must not supersede educational interest.
Mo lè fún un kọfí kan bá sọ
ẹni tó bá fẹ́ jẹ́ lórí mẹ́bẹ̀. Address tó jẹ́ This thing is getting out of hand. Awon Oni Isese Kwara State gbogbo mo fún problem. Gbogbo àwọn tó ń lọ báyìí tó ń ṣàbòsí. Inú wọn láti ẹgbẹ́ dání òrìṣà tẹ́gbẹ́ dání máa máa ṣe lòdì sí ní. Ṣe lòdì sí ṣẹ̀ṣe. Ẹ̀jẹ̀ ń bá wa jẹ́ ń bá wa mú. Wọ́n gbà wọn gbogbo òrìṣà ló máa kọ̀ ní síbí. Ẹ máa pè wọ́n wọ̀n ní dání náà. Àti àbí tí ẹ̀ tí ò bá sóbìnrin inú yín lóbi tó jẹ́ kùn tí ìṣòbìnrin lóbi.
ẹ má sọ òṣìṣẹ́ ẹ má sọ oríṣiríṣi ọ̀rọ̀ ẹ̀sìn lélẹ̀ yẹ fi jẹ̀sí lẹ̀ ọ̀rọ̀ ẹ̀ máa kọ́ orí ìjẹ̀sà ara wa ń bá dé ibẹ̀ funfun wa ẹ má da ọkọ̀ tó ń jẹ̀sẹ̀ ẹ má sọ orí ìjẹ̀sì ìdùnkọ̀ tó ń kọ́ oríṣẹ́ lẹ̀. láì mọ̀ ní gbogbo ẹ̀ ẹ má ọ̀rẹ́ náà kọ́ ọmọ kò sí dìfẹ́ ìgbòho tó wà ní ṣe dìfẹ́ ìyẹn mọ̀ ìdílé ya mú ojú tó má tọ̀jọ́ sáà ní ìlú.
A fẹ́ gbọ́ èsì àbájáde látẹnu àwọn agbẹjọ́rò wa tí wọ́n ṣẹ̀ jáde láti ilé ẹjọ́ wa lọ́yẹ̀ jáde láti ilé ẹjọ́ náà lónìí. Àwọn agbẹjọ́rò wa ni wọ́n ń bọ̀ yìí pé ẹ gbọ́ èsì àbájáde látẹnu wọn gbọ̀ngbọ̀n pàtó kàṣẹ náà pé ìṣèjọba okay, good man.
Ẹ káàbọ̀ òṣìṣẹ́ báwo ló ṣe lọ àbá.
Ẹ jẹ́ kí maybe I should just start by speaking English. Now, I want to appreciate everybody for turning up for today's session. Now, we are just from the court. We recall that last week we move our application for the bail of Azeez Adegbola Talolo, and the ruling was adjourned to today. We are just from the court now. The court, in its wisdom, ruled that he will not grant bail to the applicant. Our application has been declined and refused. Knowing fully well that the offences for which he was brought to court are available. The law is there. All the 4 alleged offences are available. And the law is clear about that. Even without filing an application, moving oral application before the court should be able to grant the defendant applicant bail. But today we were shocked, and we were not only shocked, we were miffed that the court declined our application. Nta sọ ní pé ní ọ̀sẹ̀ tó kọjá a kọ̀wé lọ sí court pé kí wọ́n fún Talolo ní bail nítorí àwọn ẹ̀sùn kan fi kàn, àwọn ẹ̀sùn tí a lè gba bail ẹ̀ ni. Òfin dẹ̀ clear yéké lórí àwọn offences yẹn wípé a lè gba bail ẹ̀, they are bailable offences. Ṣùgbọ́n gbà tá a dé court lẹ́ni ó ṣe ni láàánú pé adájọ́ sọ pé òun ò ní fún ní bail. Ó lóun ò ní fún ní bail. And therefore, I don't know, but nta ṣe ṣìkù. Mo fẹ́ kẹ́ fọkàn yín balẹ̀. Nta ṣe ṣìkù lórí ọ̀rọ̀. Nta ṣe ṣìkù. A ní ìgbàgbọ́ pé Tani Ọlọ́run ó máa jáde.
Àṣẹ.
Ó máa jáde, ó máa ní freedom very soon.
Àṣẹ.
Òfin sì tún fààyè gbà wá, n tó yẹ ká ṣe ó tún wà. Tó bá ti rí báyìí, nǹkan tá tún máa ṣe ó wà. Àwọn mẹ́tẹ̀ẹ̀ta ti forí kò. And we are going to take step. Mo ti bá ọ̀gá mi sọ̀rọ̀, Ọlá sọ pé Ọládìpọ̀ SAN, mo ti bá sọ̀rọ̀. I ma take step immediately láti rí pé a gbé ìgbésẹ̀ tó kàn tí nǹkan bá ti rí báyìí. So mo fẹ́ kẹ́ fọkàn balẹ̀ lórí ọ̀rọ̀ yìí. Ẹ má bára jẹ́ o. Ẹ má dẹ̀ fàyè gba jàgídíjàgan. Ní ọ̀sẹ̀ kejì sẹ́yìn tí wọ́n tẹ̀ tọ́jà yín, tí wọ́n bu yín, tí wọ́n lẹ̀ yín lóko, tí wọ́n fọ́ gíláàsì mọ́tò yín. A rí pé ẹ pamọ́ra, ẹ torí ẹ fàjọ̀gbọ̀n, ẹ torí ẹ dàlú. Mo dúpẹ́ lọ́wọ́ yín títí dìsìn náà. Mo rọ̀ yín, ẹ jọ̀ọ́ gbogbo ìpamọ́ra tá a ti ní lórí ọ̀rọ̀ yìí, ẹ má jẹ́ kó dẹ́kun, ẹ má jẹ́ kó sún yín, ẹ má jẹ́ kó rẹ̀ yín. Ṣẹ́gbọ́, ní tí mo lè sọ lọ́wọ́lọ́wọ́ nìyẹn. That is the situation we have just faced in the court. It is shocking and unbelievable that offences that are available have been rejected or denied. That is the situation we face now. We can just take 1 or 2 questions and we'll wrap it up.
For the benefit of our people at home,
Yes.
do you think this is an upset in the judicial system?
Well, I can only say that it is already tried that the court has the discretion to grant bail or not, depending on the circumstance. And the discretion is unfettered. And that is the position of the law. It is discretionary. He has given the reason why he doesn't want to grant him bail. Those reasons are not tenable to us. And that's why I have just said we will exploit the next step in law. You understand? To avenge the situation.
Okay, sir. What is the fate concerning the case tomorrow?
No, tomorrow's case is another bail application. We are going to move it another court entirely. Another court, another scenario. There are 2 defendants. In that case, there's Babatede. Babatede is involved. So there are 2 defendants in the other court, in the upper area court. So different situation, different scenario. Tomorrow we will move the application for bail. It does not follow that what happened there will happen there. But you see, these 2 courts must grant him bail for him to get his freedom. These are criminal charges against him, and the 2 courts must give him bail before he can be free. And I promise that we will do the needful. Yes.
Excuse me, sir. Have they ever asked you about his character or his address or something before they said it's not?
No. We have not even gotten that. Okay. The police, the prosecution alleged that he doesn't have traceable address and that he's not within jurisdiction, and many other excuses that police were hanging on. You understand? But then that is not enough. We have deposed an affidavit saying that he has credible shorties, he has traceable addresses. You understand? And that is enough. If the court have asked us to bring 2 shorties or more, we will have done that. We will have done that. We will have done that. We will have brought credible shorties to court to stand for him. Now let me tell you. You understand? Let me just say this. Well, we will do the needful in the law. It is not the end of the road. It is not the end of the road, please. I want you to understand. Now, I want to restrain myself from saying what I should not say in the public. Wọ́n ní nǹkan tí àgbàlagbà bá fi tó máa fi jẹ̀kọ abẹ́wé ló wà. So bó ṣe jẹ́ nìyẹn.
Ìbéèrè kan tí mo kọ́ fẹ́ béèrè lélẹ̀ má bínú. Níbi tí gbogbo àjọ fojú ní báyìí tí ọ̀rọ̀ dé pé a ti rí i pé ọ̀rọ̀ náà ti ta kókó. Ẹ̀yin gẹ́gẹ́ bí lọ́ọ̀yà wa, àmọ̀ràn wo lẹ fẹ́ gba àwa tàbí gbogbo àwọn èèyàn wa? Àbí kí lẹ̀yin fẹ́ kí ìrànlọ́wọ́ wo lẹ rò pé a fẹ́ lọ́wọ́ gbogbo olùgbé ayé báyìí tá a lè lọ ké gbàǹjarè rẹ̀ níbi tọ́rọ̀ dé dó yìí pé ìrànlọ́wọ́ báyìí la fẹ́ o, bóyá Ọlọ́run lè járe. Àbámọ̀ tẹ fẹ́ gbà pé gbèsè báyìí kọ́ o nìkan gbé o, because ìmọ̀tọ́ ọ̀pá délé ṣe ẹbí ajókòó, ara ajókòó, ọmọ èèyàn ajókòó, ṣòkí la lè ṣe tí ò ní tako òfin tí ẹ̀yin gbé dání.
Ẹ ṣé gan fún ìbéèrè yìí yẹn. Agbẹjọ́rò àgbà Barrister Banks wọ́n ní kí n dáhùn ìbéèrè yìí. Ìbéèrè tẹ́ béèrè yẹn kò ń ṣe nǹkan tí ó yẹ ká dá yín lónìí orí afẹ́fẹ́ ń bíbá, nítorí pé nǹkan tí àwa rí ní ẹjọ́ ìní yìí, nǹkan tá a rí ní ẹjọ́ ìní yìí, èmi ò personally tani Ọlọ́run lè rí justice mi lọ. Tí ẹlòmí ò bá fẹ́ sọ, èmi máa sọ. Adédàmọ́lá Ọlálékan Ṣólésì, call to the Nigerian bar. Tani Ọlọ́run cannot get justice in Ilorin because I've been able to feel the nerves of the police. They are unwilling to wait. They are unwilling to arrest these people even when they arrest us. I've been able to feel the nerves of the courts, both at the upper area court and the magistrate court. These people will continue to have their ways even up to the Court of Appeal. One Court of Appeal, Nibibai. So if you say you are going to appeal, we are still at the lower courts. We are not even yet at the high court. If we continue on this path up to Court of Appeal, the client wa Adegbola Tani Olohun, musibe. In my years of practice, any lawyer in Nigeria to tell me that what I'm saying is not right. I have never seen such a situation in my life. See, the law has moved on from mere technicality, slaughtering justice on the altar of mere technicality. What am I saying? The law, the criminal justice system in Nigeria has got to a situation whereby even when an accused person, somebody, a defendant that is alleged to have committed an offense which is not a capital offense, tí kò ṣe tó pààyàn àbí ẹ̀ṣẹ̀ tó pé ó máa fún lé ní ẹ̀wọ̀n ikú àbí ẹ̀wọ̀n ó máa fún ní ìdájọ́ ikú àbí ẹ̀wọ̀n gbére. Tí ò bá ní lawyer gan, ó máa fún ní bail. Adédàmọ́lá Ṣólésì sọ bẹ́ẹ̀. I'm saying it to the whole world that the criminal justice system of Nigeria has evolved to the extent that a person alleged to have committed an offense which is not a capital offense, when it comes to court, when he's arraigned, when his plea has been taken in court and he has pleaded not guilty, whether or not he has a lawyer, they will grant it, especially magistrate court. Magistrate court. A magistrate court is not a superior court of record. We can orally take his bail the very day he was arraigned. It's from that inception that they have been dragging us back. But personally, what I thought was that they just wanted to keep him for some time before he gets the bail, not knowing that they don't have the intention whatsoever to release him.
It's okay.
Today we are witnessing a synergy of failure by the judiciary in Kwara State. I'm beginning to feel we are no longer in Nigeria, as if we didn't attend the same law school. What we are saying, simple offenses, simple. Look at it in their count charge. There's conspiracy. It's the only one standing trial here. What are we talking about? We felt, okay, we want to keep him so that he can show sign of remorse. For what in the first place? What has he done? What has he done? We have applied for his bail by virtue of the law. You said, okay, we should come officially. What is wrong in that bail but mere technicalities? Just to keep him, to continue to keep him in the detention. For what? For Christ's sake. We are calling on the judiciary in Nigeria entirely. It's very, very painful that the Attorney General of the Federation is from this state. Nothing has been done. There is a governor here, nothing has been heard from them. So we are witnessing mere persecution here, and it is unfortunate. It is unfortunate. But we will just endure till we get our client out of the galley.
Thank you. Thank you. Inú mi dùn púpọ̀ láti gbọ́ ogun. Ẹ má bínú láti gbọ́ ogun tẹ́ ẹ sọ. Nísìnyí níjọ́ wo wá ní ìpàdé nílé ẹjọ́ tá a ti tàn fún un. A sọ fún yín ọdún ọyọ àmàdé sọ̀rọ̀ bí a sọ fún yín. A sọ pé a máa gbé àwọn ìgbésẹ̀ àti láà máa gbé àwọn ìgbésẹ̀ àdéhùn mọ̀. No, ẹ má wọ̀rí, a máa jẹ́ kẹ́ mọ̀ ṣẹ́gbọ́. A máa inform me in due course.
Sorry, sir. Can you talk to us briefly, very briefly, regarding what transpired in court today?
You came late. Well, we have said it. The bail of the applicant was denied, and on technical ground, the offences for which he was brought to court are ordinarily bailable, and it is still subject to the discretion of the court. Surprisingly, the court has ruled in that way. He has declined jurisdiction. I mean, he has declined our bail application, and so we will take the next step.
Right, some party are actually looking for out of court settlement. Would you want to do that part?
When the time comes, we'll look at it. We'll look at the merit.
All right. Just your full name and what you are standing for.
I'm Barrister Ademola Bank. With me is Olale Consulesi and Ole Odesoya. Standing for the defendant. Aziz.
Thank you.
Thank you. Thank you. Thank you.
Láti kàn ní BBC Yorùbá, ẹ̀jẹ̀ lè sọ fún wa ìdí tí ilé ẹjọ́ fi sọ pé àwọn òdì fún Tani Olohun lómìnira.
Ilé ẹjọ́ sọ pé kò ní address àti pé kò lẹ́ni tó lè dúró fún, and these are opinions. Tó bá fún ní bail, tó bá ní ká lọ mọ ẹni tó lè dúró fún, á lọ mọ ẹni tó máa dúró fún wa. Wọ́n á dẹ̀ trace ilé ẹ̀, wọ́n á rí pé ó lá address, ó ní family. Abẹ́rẹ́ tó lókun nídìí ni kò lè sá lọ. Do you understand what I'm saying?
Ilé ẹjọ́ sọ kínní kan ní pàtó wípé wọ́n ti remand ẹ̀ ní 17 pé ohun tí ẹ gbé wá ni pé ní 18 ẹ lọ bá ní police headquarter.
Ṣé 17 kọ́ la ti wá sí kọ́ọ̀tù ni? 17 ni náà ṣe bíjọ́ ìnáwó ti detain ẹ̀ síbẹ̀ yẹn.
Then wọ́n detain ẹ̀ ní 17 wọ́n á sọ pé ní 18 bẹ́ẹ̀ sọ pé ẹ lọ bá ní police headquarter pé gba information lọ́wọ́ ẹ̀.
Bẹ́ẹ̀ àbúrò ẹ̀ lọ bá ṣé yẹn lè fẹ́ máa bá àwọn àfáǹsì ni, and wọ́n deny bail, so is that what you want to ask me?
And that is not even enough.
Is that enough to deny him bail?
That is not even enough. In fact, if there is no application at all,
that's a needless error.
That is what we are saying.
It's okay.
Without any application at all, he's entitled to bail. That's what we are saying.
He's entitled to bail, with or without that. Pé wọ́n lọ bá ní prison. Ní 17, àbí 18, àbí 19. The guy is entitled to bail. That's what I'm saying. Is that relevant?
Kọ́má ní lọ́ọ̀yà rárá. Kọ́má ní lọ́ọ̀yà rárá ní magistrate court o. Even if he doesn't have a lawyer at the magistrate court, I'm saying that he is entitled to bail. Without a lawyer at all, he's entitled to bail. That is what we have seen in our experience
It's
as
okay.
legal practitioners.
It's okay. So, Eshegon, thank you. Babada.
Yeah, eléyìí ni èsì àbọ̀ àbájáde kóòtù ní ìlú Ìlọrin. Gbogbo ayé wọ́n fún Tàlọ́lọ́run ní ìbéè. Èyí ni àìsàn àbájáde fún wa ní ìbéèlì.
Ẹ wo kò lè rí justice ní bíbá yìí. Ẹ má sọ bá yìí. Ìbàjẹ́ kan mọ̀. Tẹ́ bá sọ nípa ẹni kò lè justice ní bíbá yìí. Ẹjẹ́ kan lè mọ̀. Tẹ́ bá yìí tẹ̀ sọ sí.
Condition of bail ẹ̀dẹ̀ ń sọ fún wa wípé lè mítọ̀. Ẹ̀yẹ̀ méjì ni òwe ẹ̀kọ́ bá ẹ̀kọ́ kan náà. Àwọn aláma wá fún wa.
Abilábì tó mú wa. Abilábì tó mú wa pé kò ní jọ́ọ̀pù bail. Ó máa mú ṣọtí wá. Ẹgbẹ́ ìgbàgbọ́ tó lè fi sọ àwọn kíní kan ní evidence àti ilẹ̀. Ṣé bẹ́ẹ̀ yìí ni kó mú ṣọtí ẹ̀ wá? Tí ò bá tẹ́ yín lọ́rùn. Tí ṣọtí yẹn ò bá tẹ́ yín lọ́rùn. Èyí ni kó mú mi wá. Èwo ni kẹ́ máa kẹ́ sọ kó wá dismiss the application.
Personally, you will not be able to meet up that, you will not be able to get your things. You understand? That is their presumption. And based on that presumption, they are denying bail. It's unfair.
When the granted, can't move and see any other state. Agbele Ekiti state, Odo state, one there, Abuja one there. Oyo state one there. Lagos state one there. Agbele other state.
It's not the way it is available in every part of the nation. So I'm relying on the authorities. Come on, man.